I've practiced election law in the U.S. Supreme Court since 1972 for a variety of presidential candidates, ranging from the less well-known ones like Dr. Benjamin Spock to John Anderson, and even one brief on behalf of George W. Bush. So that's my experience. Now, what we're looking at here is the largest election law fraud in the history of the United States, involving $1.6 million. And it also involves someone who is running for president now, Senator Hillary Clinton. The critical question is, what did she know and when did she know it? And following on that question, it is how many people have lied for her in how many venues and violated how many laws in order to keep anyone from finding out how much she knew and when she knew it, and what she herself did wrong. The cases involving Hillary Clinton are three, with the offshoots from each one of them. One is the civil case that's still going on for fraud addressed to her and her husband, former President Bill Clinton, in California. The criminal case, what's against her finance director, should have been against her treasurer and against her as well, which resulted in a not guilty verdict in the criminal court in California. However, this tape recording shows that false representations were made to the judge in that case, which resulted in, first of all, her not being indicted, and second of all, her being kept out of the case. Because the court was told, and the court told the jury, that she was not involved and she knew nothing about what went on. Whereas what this tape shows is she was involved up to her eyebrows, and that it was a lie to say that she did not know anything about it. The same fate happened in the complaint before, the first complaint before the Federal Election Commission, in which they ultimately found that her campaign had inadvertently, not really criminally, failed to account for $1.6 million in contributions honestly, and they were allowed to file another, and as it turns out, also false, the Federal Election Commission complaint said that the Hillary 2000 Senate campaign had falsely reported in excess of $1.2 million. And that too would still be an all-time record in fraud before the Federal Election Commission. But it also said that there was no evidence that she knew anything about it, and that it was apparently inadvertent, and they were allowed to file an amended report with the FEC, which, interestingly, also gave a false source for that $1.2 million, but it indicated no knowledge and no involvement of the candidate, Senator Hillary Clinton. And that is the importance of this videotape, which has just come out in public, which shows that she knew full well the level of money that was involved, how it was being used, what was being done in her name, and triggers a long list of criminal actions. Whether or not she'll ever be prosecuted is a separate question, but criminal actions by soon-to-be Senator Hillary Clinton. 5-minute videotape, which was taken in the offices of where a call was received from Hillary Clinton, but has her voice on it quite clearly, shows a number of violations of the law. First of all, it shows that she had personal involvement and personal knowledge of the details of this gala, whereas she has had her representatives in the criminal court, in the civil case, and before the FEC represent that she had no knowledge of this. So that is suborning perjury. That is obstructing justice. Furthermore, in the course of this phone call, you hear her describing how she solicited a contribution by Cher, who was to be one of the main performers at this gala. Now, what she did there would be legal only if the services of Cher to come and sing at a concert are worth less than $2,000. And no one in his right mind would say that a performance by Cher, a live performance, was worth that small an amount. Therefore, she was soliciting an illegal contribution. So that, too, is a violation of the law. Now, this doesn't mean I expect there will be an indictment of Hillary Clinton. This does not mean that there's likely to be an indictment of Hillary Clinton. Number one, the statute of limitations has run on most of these crimes, and for those that it hasn't, the prosecutors have shown a great reluctance. You remember her grand jury appearance when she was First Lady during the Clinton administration, and the special prosecutor said he had reason to believe she lied, but not enough to take her to court. So I do not expect there will be any criminal prosecutions. However, I do think it is extremely important that the American people, in considering who ought to be or ought not to be president of the United States, should consider whether a candidate for that office has engaged in a long list of criminal behavior, both personally and through associates, which would seem to me disqualify a person from that office. A little bit about exactly how federal election law works in this instance. People who want to make an independent expenditure on behalf of a candidate have a First Amendment right to do so. But what that means is they must be truly independent. They cannot be coordinated with, directed by, run by, with the knowledge of the candidate, because that would allow every candidate for every federal office to get around the provisions of how and when they spend money and raise money. What this tape shows is that, contrary to the idea that some high-minded citizens got together and put together this gala for the benefit of the Clinton campaign, that she was directly, specifically involved in the planning of this. She says on this tape that Kelly, which means Kelly Craighead, her White House liaison, had fully briefed her, quote unquote, up to the point of the phone call, and furthermore that she would keep her informed after that. So there's the connection of the candidate to this allegedly independent program. And the FEC law is quite clear. It is a felony, punishable by up to 5 years in jail, for a candidate to be directly involved in this sort of fundraising activity if it exceeds $25,000. And the FEC found that it exceeded $1.2 million. So that too is evidence that she committed a felony under federal law in the course of this very phone call.
Would you say that this could be?
Very, very seldom, because one thing politicians learn to do is to be careful, like they're always walking on eggshells. Very, very seldom do you ever get your hands on an audio tape or a videotape that shows a politician committing a felony. This, however, is one of those exceptional circumstances. It shows her committing not just one, but a series of felonies when you look at how her representatives claimed she had no knowledge in various venues after this, whereas on this tape she was fully informed and she so said. It's crime on tape, very simple. Everyone except the Democrats in the House of Representatives have recognized that William Jefferson, congressman from Louisiana, is a crook. Why? Because the FBI has him on tape accepting a $90,000 bribe, which then wound up in his freezer. Well, this tape has the same probative, proving value. It shows Hillary Clinton in the process of arranging for and accepting 1.2 or 1.6 million, depending on which source you look at, knowingly, willingly, eagerly. So it is every bit the equivalent of the tape of Congressman Jefferson. This tape shows Hillary Clinton in the process of committing at least 4 or 5 felonies under federal election law. After the gala was conducted, after the money was gotten, after the proceeds were dumped into her campaign to get her into the Senate from New York, that her representatives claimed she knew nothing about this gala other than that she attended it, that she did not participate in the organizing of it, she did not know how much money it cost, and so on down the line. All of these representations were false. And her representatives, in making these false allegations, were lying on her behalf. They were cheating justice, and they were committing perjury, and all of this was happening because she made it so. So that's 4 felonies right there, and you throw in the 5th one of the share contribution, and there's 5. And if you go at it, you could probably find more. The unique aspect of this case is that Hillary Clinton and her representatives have been able to squash investigations in all 3 branches of government by lying to the authorities that they were dealing with at the time and getting the lies accepted. We have first the criminal case in California against Mr. Rosen, where the judge instructed the jury that she was not involved where she was. We have the Federal Election Commission finding that minions had made a mistake, but she was not involved. And then, worst of all, we have the Senate ethics investigation, which looked at the criminal case and looked at the FEC case and said, we find no involvement of Senator Clinton. But here on this tape, we can show that all 3 of those are dishonest conclusions, all brought about by lying about her involvement, which this tape shows. So there she has cheated investigations in the executive, the judicial, and the legislative branches of the federal government. I know of no other case in American history where an investigation of a serious matter has been squashed in all 3 branches as this one was. Many different venues were shut down by false statements made, factual false statements made on behalf of Hillary Clinton. And that suggests, reach your own conclusion, that her power and reach is quite broad. See a prosecution, as the criminal case against Rosen was in California, where tape recordings, legal wiretap tape recordings of crimes being discussed on the media were not brought before the jury, not even mentioned. When you see that sort of thing, you conclude either that the prosecutor is incompetent, or worse, that the prosecutor is dogging the case. I'll go through the motions, I'll make the claim, I'll try the case, but I won't get too excited if I lose it, and I'm sure as heck not going to put in the most damaging evidence. Whenever you see that, it ought to, if you care about the legal system, give you great pause. And that happened here. That has not happened in all political possible wrongdoings, but it certainly happened here. For better or for worse, when a candidate lies to the press about who her or his supporters are, that is not a criminal violation. It's an ethical violation, a moral violation, but it is not a criminal violation. However, when the candidate, through his or her representatives, files a document under oath with the Federal Election Commission saying, here's where their money came from, if that statement is false, it is perjurious, it is a felony, and furthermore, it undercuts the integrity of the election process. We have dishonesty over $1.2 or $1.6 million and never any prosecution except for the one false effort, misleading effort against Rosen out in California. So it undercuts the integrity of the process, but it only becomes a law violation when it's a false report. In the PhD program in political science at American University, I did a study of 20 years of Federal Election Commission decisions. And it's interesting how clearly a bias came out of those reports. When they are considering violations by Republicans or Democrats, they go easier on them than if the violation is by a third party or an independent candidate. And it's not a slight margin, it's a huge margin. And that's because of how the Federal Election Commission is set up. It has 3 Republican and 3 Democratic commissioners, and it cannot officially act unless it gets at least 4 votes. So as long as the Republicans protect the Republicans and the Democrats protect the Democrats, the people they're going to jump hard on are the third parties and independents, and they're going to let a lot of people slide. So that's a general pattern of the FEC. The idea that the biggest fraud in the history of the United States, 1.2, 1.6 million, take your pick, was dealt with so casually is atrocious, even in the context that they tend to protect Republicans and Democrats. One of the most common prosecutions, and it happens in every election cycle, is John Smith, who owns a public corporation, or even a private corporation, and who parcels out money to other employees in the firm, and they all donate their $2,000 apiece. So the candidate winds up receiving, say, $20 or $30 or $40,000, but it all really came from the boss. And there's several of those in every election cycle. But that's small potatoes compared to this. For instance, Hillary's official statements filed before the FEC says that Stan Lee donated $220,000 to her campaign. He has stated that he donated no money to her campaign, that there was a $100,000 check for which he received reimbursement, and he has said that in his official filings on behalf of his own corporation. The FEC has shown no interest whatsoever in pursuing this particular $220,000 discrepancy, whereas they frequently send small potatoes people to jail for $20,000 in false checks. So there you have it. There's the contrast between those who are in the untouchable category and those who are not. A poignant cartoon in the New Yorker about 25 years ago. It showed a lawyer's office and all of the books, and the lawyer was behind his desk and the client was sitting there, and the caption was, "How much justice can you afford, Mr. Smith?" The simple truth is that people who have powerful friends, large amounts of money, and troops of lawyers who are getting the high dollars and will do and say whatever's necessary to protect their client, those people are harder to investigate, harder to prosecute, harder to convict, harder to put in jail. This has been, unfortunately, the truth against which the American legal system has struggled from the beginning, and we're seeing a classic example of that here. They got power in order to, let's not use the word extort, persuade people to donate large amounts of money, both legal and illegal, and then they used the money to maintain their position of power. Claiming that the First Amendment protects what she did and what she said in the civil case against her in California is a cynical and dishonest manipulation of the First Amendment, and I'll show you why. It was, I think, 3 decades ago that Senator Danny Brewster, whom I knew personally from Maryland, was convicted of taking bribes from a mail-order house in order to sponsor legislation to lower their postal bills. And his defense was, I was acting as a senator, and therefore you cannot prosecute me for this. And he went all the way to the Supreme Court, and the Supreme Court says there is no First Amendment protection if you are in the process of committing a crime to say, because I'm a senator, you can't prosecute me. So the Brewster case stands for the proposition that Hillary is both cynical and wrong in the position she's taking in the civil case in California now. The upper limit, and it's still that way today, even though inflation has been heavy, on contributions to candidates, at least as of these elections, was $2,000. When a candidate solicits and coordinates a contribution greater than that from any individual, that contribution is illegal on the face of it. Now we subtract $2,000 from $1.2 or $1.6 million and we say, hello, this is the fattest illegal contribution in the history of the sport. It's as simple as that. There is no ifs, ands, or buts about it. If she was involved in soliciting and coordinating, then it's illegal. What is unique is that she is not at all 100% asked questions. When you look at the background of the media, and there have been plenty of polls saying, how do the media vote? Where are their politics? They are somewhere between 60 and 70% Democratic. Therefore, they go easier on Democratic candidates than Republican ones. This is always true. However, in Hillary's case, the questions don't get asked by any part of the media. And they also don't get asked at her town meetings because they screen the people who go in there to make sure they're going to get friendly questions. They don't face an open audience. So that aspect of what she is doing is, as far as I can see, unique. That the questions about these critical legal cases do not get asked. As a lawyer who spent an awful lot of time in court, the simple truth is, I don't know is often for a cover that I do know, but if I admitted it, I'd be guilty of something, and therefore I'm going to claim I can't remember. This has been a pattern with Hillary Clinton, with Bill as well. Remember, he used I don't know when he was questioned by the judge in the case in Little Rock. She used I don't know, what, how many times was it? 47 times before the grand jury in Washington. When people who are allegedly smart, and when people who have fine steel-trap memories, generally when they're talking in front of people, suddenly can't remember, that ain't true. And it does not establish that they're free and clear. It doesn't make the event go away. All they're trying to do is duck responsibility for the event. It's as simple as that.